All right, we now call Jenna Ray Harn in cause number 25 DCCR289. That's you? Here with Mr. Grove, your attorney and the state's attorney. As you know,
Let's stop for a moment. Hitting a public servant isn't the same as getting into a bar fight. In Texas, it's a third-degree felony, which means Jenna Ray Harn could face serious prison time up to 10 years. The situation is already very serious for her.
charged with the third-degree felony of assault on a public servant, which carries with it up to 10 years in prison. Earlier, was the defendant entered the plea already?
Yes, sir.
Yes, sir.
It's not on the
She entered a plea, yes. The
Earlier-
pre-sentence report was ordered by the court.
Yeah, I've got all of that. But there's nothing on the jacket that shows she pled guilty. You've entered a plea of guilty to the third-degree felony of assault on a public servant. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? Can you tell me what date she entered, Jenna Ray Harn, in 25 DCCR 289, entered a plea of guilty, please?
July 11th. So,
It didn't make it on the jacket or anything.
July the 11th.
that's why
I believe it was the date. I don't have anything in writing. On that day. That's what I was over my family.
Could it have been June? No, July?
My file shows July 11th.
7th is cut off. Okay. It
I
looks
believe
like
that's
I've got
correct,
papers in
Judge.
here dated 7/11/2025. The agreement that you entered into was that whatever sentence shall not exceed a cap of.
Here's an important detail. The deal limits the sentence to 5 years. That means Jenna won't face the full 10 years, but she could still get anywhere from 2 to 5 years in prison. It's kind of like taking a gamble, but instead of money, it's her freedom at risk.
5 years in prison. So we are looking at no less than 2, no more than 5 years confinement in prison. Deferred or unadjudicated probation can be assessed. She looks like she has a final conviction out of Jasper County for evading arrest, but she can still get regular probation from the court, but
Yes.
not a jury of slam. Okay, those are your options. Go ahead, Mr. Grove. And the pre-sentence report has been prepared. Have the parties had an opportunity to review it? Or are there any corrections or changes to it? State?
Not for the
And
state.
defense.
Judge, and this is not a change, it's just something that I noticed on page 2,
Yeah.
restitution issues. It says restitution issues, and there are none. I believe there is a restitution issue, but it was not part of the plea bargain, restitution be paid. So I'm not objecting to that. I just want to make sure that I'm not waiving anything because I think restitution may be applicable.
I don't show any requested by the complainant in my file. Oh, wait, yes, I did. Hold on. Amount of loss. This is not even the right person.
I believe
Nothing in my file, Judge.
I believe, Judge, what happened was a letter was sent out.
This is where things get complicated. Restitution. The victim wants money for medical bills and damages, but the court doesn't even know the exact amount yet. It's like asking someone to pay a bill without showing them the receipt. That kind of missing paperwork is what makes hearings like this so messy.
By Mr. Giblin saying that, you know, if you have any restitution, send it in or something like that. I have not seen a number.
There's
There's no restitution.
no restitution.
However, there is restitution involved in the case. Well, just to get into it, because on page let's see,
You're talking about the pre-sentence
the
report.
pre-sentence report, yes, sir.
And that's made a part of the record for all purposes.
Yes, sir. And this is not an objection to that. but that there was an analysis made by the complainant who basically, I guess, said that talked about how much that this case had changed her, and that now she could no longer work as a registered nurse because of this, and she was having to pay daily records to pay restitution and medical damages from this. So there's not a number that's mentioned in here. The probation officer did not put one in.
Miss Ramirez or Melanie Ramirez was. See,
They get it from us, Judge, and if we get a request in from the complaining witness, we send out a letter, say, if you have anything, send it to us. And I didn't show anything in my file that
I know,
says.
but the pre-sentence report clearly says she's got medical.
Well, she says she did, but they have to send in something for us to be able to give them out,
Then-
Judge.
Okay. In addition to the physical and emotional impact this assault has had, I have suffered significant financial loss due to medical bills, missed work, co-pays, etc. As I struggle to work overtime to pay medical bills
I'll double check
and
Judge,
go
and
to
see if she got
therapy
anything
to
in.
heal from the trauma, I have one request from the court. I request the defendant be sentenced to state prison.
This is the big moment from the victim. She isn't just asking for money, she's also demanding prison time. Her point is clear: violence against public servants should never be accepted. It's a strong argument, especially since she's a nurse, someone people see as a caregiver and protector.
Violence against public servants cannot be tolerated. And this is, thank you, regards, the complainant, registered nurse. Well, something happened there because I'm looking at restitution that.
Judge, and I know it says that, but like I say, I cannot ask for something I do not have a number of.
All right.
I can't just say generally ask for restitution. I'm looking to make sure in the file that there's nothing there.
Okay. Go ahead, David, on behalf of the defendant.
Let me give you a little bit more background on Ms. Horn, and I'm going to try to be brief. Ms. Horn has suffered from mental health problems, treatment, and services for many, many years. Starting back on page 4 under the substance abuse history, it shows basically that she has been exposed and has used alcohol, marijuana, just about every drug you can imagine, as well as synthetic marijuana during the time that she has been treated. This particular
Voluntary use.
I'm sorry.
Voluntary use of the substances.
I don't dispute that. It does not say, but I think it's in there, and I just want to make the court aware of it.
And you're not asserting she's incompetent or insane.
No, sir.
Okay.
No, sir. I believe she is competent. I just wanted to make the court aware that she does have a history of this usage, although I don't.
At this point, the defense shifts focus to Jenna's mental health history. It's a common courtroom strategy not to excuse the crime, but to present it as the result of untreated illness. The real question is whether her mental health explains why the violence happened, or if it just makes deciding the punishment more complicated.
Each individual time or where it was. Now, on this particular occasion, unfortunately, Miss Horn was arrested and taken to the Baptist Hospital, Beaumont Neurological Center, where she was treated. And as the court is aware, that's where people that have mental and intellectual problems quite frequently are treated. Unfortunately, this is where the incident occurred. And again, trying to be brief, it shows that she was in pain and told the nurse Ms. Storm that she was in a great deal of pain and wanted a shot and hit her, I believe it says 4 or 5 times. There was another Baptist Hospital employee who was present who went in to help the nurse. They eventually took Miss Horn off the lady, but she did suffer the trauma and as a result of this violence. I mean, it's also clear that I believe from looking at this record and talking to Miss Horn's family, she has been in, I believe, 8 or 9 different mental health treatment facilities, including the Baptist Hospital Neurological Center. And it's one of those things that Ms. Horn is not saying that this didn't happen. She is not saying she is not guilty. But the fact that it did happen, she feels like she ought to pay restitution to Ms. Storm, the victim in this case, as well as the other individual who was not injured to as great a degree as I believe Ms. Storm was.
Now comes the defense's last big request: probation instead of prison. The ironic part is that they also want her to pay restitution, even though she doesn't have steady work. So the court has to decide, is it more important to punish her, or to focus on rehabilitation when she might not even be able to pay what's owed?
And yet this is a situation where she didn't have the money, she cannot maintain employment, and doesn't have anywhere else to get the money to pay any of this restitution to Baptist Hospital as well as to the victim. And so I would ask the court to place her on either deferred adjudication or regular probation, and order as the primary service that she get employment and pay for this. She also has indicated that she will do anything she can to get help for her problem, whether that includes safety, MIP, anything, if she can just get it, because she's not been able to have any treatment for this problem during her recent history. And again, Judge, that's not, I'm not saying this very well, but again, I would ask that the court consider placing her on some type of supervision and not sending her to TDC. And at the appropriate time this morning, we'd like to talk to the court too, but I'm not sure that's this time.
Yeah, go ahead, say.
Judge, I really get upset when we start using restitution as a form of making us give somebody probation, and that's just not going to happen in this case. You can see what the complaining witness went through. She did request $5,000 in restitution for lost wages, medical costs, and travel expenses that she had to do during this time. But you've heard that she can't pay that. The defendant cannot pay that. She can't hold a job. She doesn't have the money to do it. But look what she did to this woman. I mean, this is not like she just kicked out or just lashed out one time because she was angry or mentally ill. She wasn't getting her way. She punched this woman in the face, and as a direct result of the actions in page 2 on the complainant's statement, as a direct result of this, the defendant punching me in the face numerous times, causing me to lose complete bladder control, sinus injuries, neck strain, depression, and anxiety. It will take time to heal and to adjust to my new normal in the hospital and a new department. After she has dedicated numerous years to working with mental health patients, she said, I've dedicated the last 30 years of